Okay, good afternoon, everybody. My name again is Shane Bajat, and thank you for joining this webinar. It's the part two of our series. We will begin shortly, like about 4 minutes. So far, we have 3 participants, so we'll be waiting. We'll start exactly at 1 today because we only have an hour to do this participation. So yeah, so we'll start in a few minutes. Thank you again. Okay, good afternoon, everybody. My name is Shane Jacques, and I'm the outreach manager from TS. Thank you today for doing our webinar. Today, the part two of the two series of webinar we have for this month is about estate planning, and our presenter again is Danielle. Thank you again, Danielle, for doing the presentation.
My pleasure, and I just want to make sure that you're hearing me and you have my screen up.
I'm gonna stop sharing my screen in 1 second, and I'll let you know if I can see, but I'm pretty sure I can see it because I saw it before.
Wonderful. So wonderful. Thank you, Shayna. And while she's setting that up, hi, my name is Daniel Timins. I'm a trust and estates and elder law attorney, as well as being a certified financial planner. Today, we are following up from last week's presentation, which is more or less, that was estate planning during your life. And this is what happens after your life, basically speaking. There's the two, believe it or not, have some similarities. I know it doesn't seem like that. But taxes, you always seem to get taxed whether you're alive or you're not. So there you go. But the general idea today is that we're going to focus primarily on what happens after you pass away. And if you have any questions, make sure to save them until the end, and we'll make sure to answer them. So please make sure to email Shayna, and she'll be able to do that. So just let me know, Shayna, whenever we're up, and I will begin to run.
Yeah, so now you can share your screen. Like you said, if any questions, wait at the end of the presentation, or you can post it on the Q&A box, and I will gather all of them and answer it at the end of the presentation. Again, we are nonprofit. If you have anybody that needs help with it, we'll help the caregiver caring for loved ones, and all fivefold. At the end, if you have any question about PSS, you can also add it on the Q&A box. Yes, I can see your screen very well, and you can start.
Wonderful. Thank you. So, hi, everyone. Dan Timins, and once again, I won't waste time telling you about me. Let's get to talking about you. Before we do that, of course, being in the legal profession must show you the disclaimer. Just because something applies to some people may not mean that it applies to you. Though generally speaking, it might. Again, this is just meant to be general conversation. If you have more specific conversations, you can try to figure it out on your own, but I tend to suggest that people work with an estate attorney, particularly if you cannot figure it out on your own, because that's how things work. When you don't know, you get someone professional. Just to remind people, what are we talking about today? We are talking about money. That is the bottom line of what the point of this presentation is. It's about minimizing taxes and court fees as well as attorney fees, maintaining control after you pass away, and more or less some steps you can take to minimize some estate nightmares. And the progression of our program today will be 1, 2, 3, 4, and 5. Property that transfers outside of your will. This does include retirement plans, but I add a separate portion here. Then things that transfer through your will and what that means as far as probate is concerned. Then we discuss trusts. Trusts also pass outside of your will, or the property transfers to other people outside of your will. The important thing isn't just having a trust, it's understanding how they work and making sure they are funded. We will review that. And then with our leftover time, we'll be going over avoiding unforeseen problems. Just for you who don't know this, my office is in Midtown Manhattan. My mother is so proud. But that being said, the traffic on the street is awful. So you will occasionally hear people who are honking. And I'm giving this to you from my office, from downtown, or actually Midtown Manhattan. So those things happen, and I apologize profusely beforehand. Write the mayor if you have any comments to tell him. So remember, when we're talking about transferring property, this is kind of our preamble for today. We're transferring assets when we talk about estate planning. We don't talk about transferring income often. And here's why. We don't have much control over income. I mean, if I have Social Security and then I pass away, or if I have a pension, there's one person who can receive it, but that tends to be my spouse. It's very rare that someone other than my spouse can get it. After my spouse and I have passed away, that income tends to disappear. It's not easy to transfer, and there's really not a lot of play. Income just kind of happens. You either get it or you don't. So on occasion, we'll talk about income and estate planning, but we generally focus on assets. Remember, assets are what you own now. Income just comes in on a monthly or weekly basis, or even quarterly. Assets, you have them. You know, it's like a bird in a hand is worth two in the bush. You can completely control who has them and when. You can trade them, so you can turn your cash account into stocks, into Bitcoin, whatever the heck that is at this point, unless you already bought it really high, in which case now you know. It wasn't what you thought it was. But you can change the nature of the asset. We are talking about assets today because income, very hard to transfer, if at all. You don't really have much control. Assets, you have control over who gets it, how they get it, and when they get it. So, the concept we will be going back to today consistently, whether it's stated or not, will be your gross estate. That is all the assets you own when you die. Everything. So, there are two ways, legal theories, that transfer property. The bottom one, your will, people have heard the term probate and they say, got it, all right, understand. That may not transfer a lot of your property. Much of your property may transfer by your non-probate estate, meaning property that is transferring outside of your will. I could say in my will, my wife gets everything, but if I have an insurance policy that says my mom gets it, and then my retirement plan says, you know, the Hump Water Buffalo charity gets it, those other beneficiaries get it. It never makes it to my will. Those properties and that asset transfers not through probate, but by something called operation of law. And so we call them testamentary substitutes because your probate assets are your last will and testament. These are testamentary substitutes, meaning things other than what transfers by your will. Both of these legal processes covers property that is your gross estate. Your gross estate is comprised of both probate and non-probate assets. So let's get to the first one. It's the term you don't know, but you actually understand what it means once I tell you because it's all over. Transfers outside of your will transfer by operation of law. They just kind of happen. There's an operation under the law that says, you know what? Let's just transfer it to you and we don't need to go through the probate process. The idea is with operation of law assets, we know who's receiving the money the moment you die. There is a beneficiary that we can identify immediately upon your death without looking at any other outside documents, just the documents that you have regarding that account as to who receives it. All that's required is having an original death certificate. And people say, well, I don't have an original. Get an original, because photocopy doesn't always work. Remember, photocopies of death certificates are not binding. I will add, if you have a family member who passes away, it's always good to get a few extra death certificates. They never expire. They're like your birth certificate. Unlike your driver's license or your Medicaid card, or Medicare card, which eventually expire, your death certificates never expire. So it's always good to get a few extras. So what types of assets are transferred outside of our will? What kind of property is transferred by operation of law? Like I said, life insurance. I name a beneficiary on life insurance. Retirement plans, such as my IRA or 401k plan. I may have a named beneficiary on that, or a few. We'll talk more about that as we go on. Joint property with rights of survivorship. So if I own a home or co-op shares for people in New York City, or just a bank account or a brokerage account. If my wife and I are named on that account and I pass away, she in tears goes to the bank. She finds out how much is in the account. She cries more, and then she takes it. In fact, she doesn't even need a death certificate because she's already a partial owner on joint property. Joint property does not transfer by a will. If, for example, I have an account that I want to maintain in my name, or there's something that I can't transfer, like maybe I own a small business. In my case, I own a law firm. My wife is not an attorney. She can't have access to the accounts. Typically, what I can do sometimes is transfer some of these assets as transfer on death. We'll talk about that as well. Then we have trusts. Trusts typically pass outside of wills if they are separate documents. We will discuss briefly how you can create a trust in your will. I'm talking more about living trusts here. And then any existing contractual agreements. So, for example, if I have a prenuptial agreement, it may overrule some other types of property ownership that I have, but it has to be an existing contract. So let's talk briefly about jointly owned property. You don't even necessarily need a death certificate. I know I say that you do, but you don't. You just got to show up because in a joint account, for example, you each own 100% of the property. And I know for those of you who are good at arithmetic, you're saying, but wait, there are 2 of us or 3 of us or 4 of us, and wait, there's only $10,000. You tell me there's $40,000? No, of course I'm not saying that. What I'm saying is, legally speaking, either one of you can withdraw that entire amount. So you all have equal rights to the entire amount. So if I do pass away, my wife, Michelle, doesn't need to do that much. She doesn't even need a death certificate. I know it says you need a death certificate, but not really. There's no probate required. There is no legal process regarding my will that's required. Now, the positives of this is that it's easy. If something happens to me, even if I'm not even dead, if I'm incapacitated, my wife can go to the account. This may be where the majority of our money is, where, our bills get paid every month, and she can use that money. And there are minimal transfer costs. It really doesn't cost anything to take money out of a joint account. Like if there's joint real estate, all right, I have to do a deed transfer. A deed transfer isn't that big of a deal. It's a few $100. We change the name on the deed from me and my wife to I'm deceased. Now it just goes on my wife's name. It's a few $100 to the municipality. Pretty easy stuff. All she needs is a death certificate in regard to real estate. Now, the negative is this. If you have a joint owner who you don't really entirely trust, or someone who's under a lot of financial pressure, like maybe a child who has creditors, they can always empty out the account, and then you're stuck. There may be gift tax costs and consequences as well. For example, when I have parents who try to help their children buy their first home, and then there's co-signing on a mortgage, or there's co-signing on the property, and both the children and the parents own the deed, it can be an issue. Again, it's easy to transfer at death, but there are some downsides to it. Which then brings us to life insurance. And again, the beneficiary on a life insurance policy just needs a death certificate, and then they have to cross their fingers and hope they're named on the beneficiary designation form. So if you have a policy on your life, you are the insured individual. You can never change that. I can't go to, my admin who's female and 20 years younger than me and is going to live gazillion years longer than me and say, why don't we start by having you insured, and then we'll change that to me so that when I die 5 years from now, I only have to pay at your rate. That's not how it works. The insured on a policy never changes. The owner can change. And the big the power, I would say, of the owner is this. There's a power and there's a plus-ish downside, just a thing. The owner can always change the beneficiary. So I'm always the insured on the policy. You can't change me. When I die, it pays out. I can't say, well, it was on someone else and now it's on me. But I can change ownership, meaning I can transfer this policy to someone else's ownership who can then change the beneficiary. So when I die, that beneficiary, whoever the owner has named either now or in the future, because they can always change the beneficiary, receives the money. And it's actually a contract between a life insurance company and ultimately the beneficiary, not even me, the insured, even though I pay the premiums, because it's a promise to pay out in the future. Next, property that continues to transfer outside of a will, because we know who receives the money the moment I die, are transfer on death accounts. They are occasionally called in trust for accounts, not to be confused with living trusts, and sometimes we call these payable on death. Now, this is an account that names a future beneficiary who can't touch that money now. So, for example, my wife and I were married, and she says, Dan, I have some assets that pre-exist the marriage. If anything sneaky happens, or my dad gave me this money. If something happens to me, I want my dad to get it. And I say, I love Gus, no problem. She can have that account changed from just her name to in trust for or transfer on death to her father or her mother. Mother-in-law will get it all anyway, but she's good to me, so good for her. And even better for me. But the bank accounts and brokerage accounts that you have in your name only, like if you are unmarried and you want to avoid probate, which you'll see is a pain in the neck, you can say, I don't want anyone taking this money now, but when I die, I want to make it easy for them. You change that bank account to in trust for. So an example is the Daniel Timins checking account will be in trust for my wife, Michelle Timins. Or if she has a brokerage account, she could say the Michelle Timins account, transfer on death, Daniel Timins. And I say I forgot a little quotation there. I apologize for that. If you have bank accounts or brokerage accounts, particularly if they are small accounts, I highly recommend you consider going to your bank and brokerage institution and say, I want to name a beneficiary. Because otherwise, when you pass away, they're probably going to have to go to probate in order to transfer that money, because we don't know who receives it when you die. This way, you name a beneficiary, they just show up with a death certificate, you avoid probate on that asset. Good thing to do. Now, some people say, well, what about real estate? I want to make sure my children get my house without any troubles when I die. I say, no problem. You will create what is called a life estate. This is from like old England type stuff, where someone realized one day, you know what? I don't want my kids to kick me out of the house, but when I die, I want to give it to them and I don't want them to have any trouble paying the bills, because don't forget, probate takes a few months. I want them to have access to that property, and that way they can list it instantly. Well, life estates are basically transfer on death accounts, but they are for real estate. So you own the house the rest of your life, and then your future beneficiary receives it when you die. So here's an example. I will change my house from the Daniel and Michelle Timins ownership on the deed to Daniel and Michelle life tenants with AJ and Marie as my remainder beneficiaries. They get the remaining portion when me and my wife pass away. All they need are our death certificates and to update the deed with the county clerk. That's it. No probate required. You don't have to worry about the court delaying things or scrutinizing things regarding the will, etc., etc. They get it the next day. After they get both death certificates, they can list the property, they can move into the property, they can do whatever they want with that property. So it sounds pretty good, right? You're like, well, I can avoid probate this way. I don't need to deal with wills or anything like that. Why doesn't everybody do this with everything? Well, if you're married, you may already have the majority of your assets, maybe even all of them transferring outside of your will. The downside is this, two things. Number one, if you're not married or you don't have someone that you trust to receive this, you probably don't want to name them as a joint account holder. You may want to name them as a transfer on death beneficiary. But more importantly is this. When you do these things, you give up, it says control, you kind of give up future control, really. And the big problem is sometimes your beneficiary is his or her worst enemy. Or, they do things you don't like. Like if my wife gets remarried, which I wouldn't blame her. I can't believe she married me in the first place, frankly. But if I die and I leave her everything, and then she meets Sven, and Sven, the pool boy, I know we live in Manhattan, so it doesn't make any sense. But you get the idea. I don't want Sven to get that money. He's going to be 25 years younger than her. And then I get worried. Well, that can be a problem, right? But I left everything to her outside of by operation of law, outside the will. I don't have any other controls over it. Now, the problem with other beneficiaries is that it gives them no creditor protection. When I leave money to certain people, life insurance, when I leave it to a beneficiary, they get some creditor protection. But if I leave my transfer on death account to them, no creditor protection. They're creditors. Visa card, I shouldn't pick on them. American Express, I'll pick on them. They can just start claiming that money again. If the beneficiary has substance abuse problems, or they're a minor. Remember, I can't leave minors money outright. But here, this is what every parent does. I leave my life insurance policy to my spouse, and then if my spouse dies with me in that same terrible plane crash, I leave it all to my kid. Well, my kid is 7 years old, and if it seems wrong for a 7-year-old to inherit $1 million, something doesn't seem kind of right, it's probably not right. And in this case, it isn't. You can't leave minors money. The problem is they name that beneficiary, and now there has to be a guardianship proceeding because a minor does not know what to do with $1 million. At least this minor didn't. You can't choose how the person receives it. So, for example, if I have family stock in a company that I created, or if there's real estate that I really want my child to hold on to, I don't usually recommend that, but some parents want that. You know, a client gets what they want. They pay a decent amount of money, they'll get what they want. If you leave it to them outright, they can sell that property however they wish. And worst is that if you leave money outright to individuals who are receiving government benefits like Medicaid or supplemental security income, that's more or less like Social Security disability for people who haven't worked a lot, people who've had disabilities since they were very young, you could get them booted off of those programs. So if any one of these things are an issue for you, stop, take a look, and say, maybe I shouldn't have these types of properties going directly to these beneficiaries outside of my will or some other means. Which then brings us to, well, why don't we use a trust? Now, you'll see more about trusts as we go forward, but trusts are also property that does not transfer by a will. That's right. The difference is I can leave constraints on this property. You know, all those things I had on that last slide, all these problems, I could deal with all these things, but with a living trust. It does transfer property outside of probate, but it's still a written document. It can say, if this, but then that, but if that and this, then this happens, etc., etc. Beneficiary has substance abuse problems, not going to give it to them. Beneficiary predeceases, well, the money goes to their children in trust, but they're going to be minors, so okay, it goes to them for their health and education. Then at 25, 30, and 35, they get the rest of the money in tranches. So the idea is that after you pass away, you can control the assets. Unlike just leaving a transfer on death account to someone, a trust will allow you to control the distribution of that property. There is no court oversight with living trusts. These are separate documents from your will. The court is not involved. With the will, when you die, absolutely the court has to be involved. 100% must be involved if property is transferring by the will. Trust does not require the court whatsoever. And it's created during your life. Now, like I said, some wills have a small section that creates a trust within the will called a testamentary trust. That's a part of your will. That's not a living trust. Your will is testamentary. It's when you die. So if you create a trust in your will and then you go to one of these socialite, your cocktail parties and, the highfalutin people next to you are joking around and they're talking about their trusts and they say, oh, tell us about your trust, Margaret. And you say, well, I have one in my will. They'll probably laugh at you because that's not really a trust. It's a testamentary trust. So watch out for highfalutin people. Next comes to retirement plans. This is our second section. I make a little carve out here for people because the closer we get, or I should say the more time goes on, the more money people have had in retirement plans. They started creating these tax-deferred plans in the 70s, and now those people who started with them are now starting to finally retire. Or they're taking required minimum distributions because they're 70 and a half. So I tend to carve out a little extra time nowadays for retirement plans than I used to. Now, this includes IRAs, 401ks, 403bs, certain types of pensions, not the one that says, I work for General Motors and I get $2,000 a month for the rest of my life. Those are different types of pensions. These are assets, not income. That type of plan is an income plan. It's called a defined benefit plan because you know what benefit you're getting. These are defined contribution plans. You know how much you placed in there, and you know how much is in there. And again, the beneficiary does need a death certificate to collect the money, and they need to be the named beneficiary on the beneficiary designation form. Now, here's the big thing about retirement plans. Remember, if you reach 70 and a half, you have to begin taking required minimum distributions. And by the way, whether you do or don't, your next beneficiary will have to take them at sometimes as well. But before we get to other beneficiaries, let's talk about you. When you turn 70 and a half, the year in which you turn 70 and a half, you have to take a required minimum distribution by the end of the year. Now, this is right around the time called your required begin date. Technically, that's 71, but I'm going to keep it easy and just say, imagine it's the year you turn 70 and a half. This is what your required minimum distributions look like. So you're going to look at your entire retirement plan. You have $100,000 in your IRAs and 401ks all together. You know, you have a small one here, a bigger one there, a bigger one there. And you're 75 years old. You will have to take out $4,370 this year if you're 75. Then, if you're 85, you see the percentage has gone up. So you've gone up to 6.76%, more than 4.37. The more important thing to realize is this. You see, early on, you're not really going up a high percent. Yeah, you're going up like a fraction of a percent. When you get to your 90s, you're going up almost 1% a year. It's one of those charts that goes up like that, you know, an exponential chart. You have to take out a higher and higher and higher percent. For a lot of people, once they hit around their 80s, you know, it's very hard to outpace your required minimum distributions. If you have a few good years in the market right around here, yeah, around your mid-80s, you may be able to outpace your required minimum distributions. But eventually, if you live long enough, it doesn't matter how well you invest, everyone's IRA starts going down. You just can't outpace the required minimum distributions once you get to your mid-80s typically. So now let's say you die. So now you're pushing daisies. Well, what happens then to your retirement plan? You're taking required minimum distributions, right? And you're 84 and you pass away. And your spouse is 6 years younger than you. Well, what happens? Your spouse can place your retirement plan into his or her name. So if I die, I'm a few years older than my wife. I die. My wife can take the Daniel Timins IRA and turn it into the Michelle Timins IRA. And whereas when I was alive and taking distributions, for example, I was taking out 6.45%. Well, I die, she's 80, let's say, 4 years younger. She's taking out a smaller percentage than I am every single year. My wife, and same-sex couples now as well, as long as they are married, is the only individual, or I should say spouse, is the only individual who can transfer your IRA to his or her name. That's it. So if I pass away and my spouse is younger than 70 and a half, doesn't matter if I've begun taking required minimum distributions. They can transfer my IRA into her name or his name, provided they're a spouse, and they don't have to take distributions until they turn 70 and a half. Now, this is the other thing that I don't really have time to get into. Remember, your retirement plan has protection from all creditors except the IRS and your soon-to-be ex-spouse. But we're not worried about that. We're not talking about divorce today. You have creditor protection over your retirement plan. Now, if you were a state employee and you have one of these state plans, it's a little more complex. That's not what today is about. That's a whole different conversation. Let's stay on point. Now, I always tell people to consider naming their spouse as their sole primary beneficiary. Really, it matters what you want. You know, if your spouse says, I don't need this money, I got plenty, you know, your pittance of the funds in your retirement plan not worth my time. Okay, don't leave anything to your spouse. But, you know, for required minimum distribution rules, it makes sense to primarily leave your spouse because, number one, they can place it in their own plan. And number two, the big thing is if you leave it to somebody else, you always have to, if you have multiple individuals, figure out who the oldest individual is to determine who gets what percent of the plan on any given year for required minimum distributions. Which brings us then to those people, non-spousal beneficiaries. You know, I sometimes push the envelope. I won't joke as to, you know, polygamy. You know, typically my understanding is that most people only have one spouse unless you get divorced multiple times, which is possible as well. Been down there myself. Welcome to the club. But the important part to remember is this. You typically, when you die, only have one spouse, if you have any whatsoever. So everybody else, I'm not going to assume everyone has a spouse. Everybody else does not get to transfer your IRA into their name, their own IRA. So with me and my wife, Michelle, the Daniel Timins IRA became the Michelle Timins IRA. However, now, and this is an unfortunate name that I placed in there because it just makes it more confusing, but if I have a half-son named Tim Daniels or something like that, whatever, the Daniel Timins IRA becomes the inherited IRA for the benefit of this other individual. It is not an IRA. It is an inherited IRA. Required minimum distributions must begin the next year, basically. It's a little more complex than that, but not by a heck of a lot. Now, the problem is that inherited IRAs also lose their creditor protection. Now, the good news is this. Most financial institutions will not allow my child to take my IRA and place it into his or her direct IRA account. Most financial institutions are smart enough not to do that. But, however, if they do that, it's 100% penalty. So don't let them do that. Make sure they place it in an inherited IRA. You have a discussion, hey, holidays are coming up. Sit down your kid on your lap and have a discussion with them about this, okay? Now, the big thing about required minimum distributions, like we discussed, is that you have to know how much people are taking out at any given time. Now, the big thing is you need to have what's called a designated beneficiary. That basically means you need to have an individual, a person, right? That designated individual or that designated beneficiary is permissible for us to figure out what their life expectancy is, right? I mean, more or less, some actuary determined how long I was going to live before I breathed my first breath. Only a person or a see-through trust can be a designated beneficiary. So it's a certain type of trust, but this way we can figure out the life expectancy of that individual. A person must have a life expectancy in order to stretch IRA distributions. Those require minimum distributions. Now, if I name one entity, like a charity, as a 1% beneficiary on that plan, I ruin the plan for stretching purposes. My beneficiaries can't pull out money gradually for the rest of their lives. They have to take all the funds out within 5 years. So here's the hypothetical. You pass away at 88. I know that's almost young in my world. If you reach 88 and you die, something happened bad. But the problem is you messed up. You named 3 of your kids 33, 33, 33, and then you named, like I said, the Humpwater Buffalo Foundation as a 1% beneficiary on your IRA. All entities have to have a life expectancy or else they don't get to stretch the distributions. So you messed up. 1% goes to charity. You figure, oh, this only affects 1%. No, the whole plan must be distributed within 5 years. And here's the problem. You were 88. Your kids are probably in their 50s. Or the beneficiaries are probably younger. They're probably in their height of their earning years. And now they have to take all these funds out in the height of their earning years the last 5 years. Bad, bad news. If you want to leave money to a charity and you're using a retirement plan, and you also want to leave money from your retirement plans to some individuals, create 2 different plans. Have one that's solely charitable and the other one that's going to individuals. If you have questions about that, feel free to reach out to me and ask those questions. I'd love to spend a little more time. We're running a little bit behind, so I'm just going to kind of skip this slide, but you can always look at it later. Discusses required minimum distributions. Now, this brings us to Act 3 with wills and probate. Now, what exactly is probate? Well, probate is a legal process where a court oversees the appointment of a legal representative, the person called an executor, who represents your estate as if that person was you. We say they step into your shoes. More on that later. And collect assets you still own after your death. Anything transferred by life insurance, you don't own it. It's already been given to somebody else, right? Joint of property, that's not transferring by your will. Someone else gets that. Anything still in your name after your death. This will allow them to pay off first your creditors. They can bring lawsuits on behalf of you or defend them for you if, you caused the lawsuit. And it pays any remaining beneficiaries that you've named in your will. That's probate. Now, that's probate in a nutshell. Well, you say, well, I didn't create a will. What happens? Well, you wouldn't be the first person. In fact, you probably win the award for, 50 millionth person in the state of New York alone. This is who receives what? If you have no will and you have money that transfers outside of operation of law, meaning it would have transferred under your will, but you don't have a will, The state has a default. This is New York's, just by illustration. It's close to what other states are. If I'm married and I have no children, any property that would pass by probate instead passes by what's called intestacy. You know, that last will, and testament. This is Latin. Intestacy means without a will, basically. Non-testate. If I have a spouse and children, my spouse first gets $50,000, and then she gets 50%, and my children split 50%. Now, usually when I get a spouse or couple in here, and like the spouse hears that, they say, "Sign me up." And I say, "You know, let's create this will. Let's do this." And I say, "No problem." And then I know I got him. Okay. Now, let's say that I was never married, but I have children, or I'm divorced, or my spouse has passed away. My children then receive 100%. Now, remember, and then after that, if I have no children, my parents. Once you hit a level in this list, the later people don't get anything. So you see, as you get further down, you know, around like aunts and uncles and cousins, if I have a living parent, my aunts and uncles aren't entitled to anything, all right? It cut off on number 4. If I have no spouse and no children, my parents who are alive have the right to my estate. If they pass away, my siblings. It doesn't matter that my aunts and uncles feel entitled to my money. They have no right to it. If I wanted to leave it to them, I should have placed it in my will. But remember, we're saying you have no will here. This is who receives it. And see, you know, you knew deep down inside that at some point the state's going to get in there. If you don't have a will and you have no relatives closer than cousins, which does happen, the state receives your estate if you have no will. Yep. Now, again, you could have named the beneficiary on these accounts, and I typically recommend people who have no close relatives do that. All right. These are the people that are denied under intestacy, people who get nothing. Your life partner doesn't mean that you lived with your boyfriend for 42 years. When you die, he gets nothing. You know, I'd say if you liked them, my statement is if you liked them, then you would have put a ring on them, right? Or someone else said that. Anyway. That's the idea. You should have put a ring on them. Your best friend gets nothing. Those people who are not in the priority list. So again, you know, if I have children, my parents are entitled to nothing because technically by law, my children are closer to me than my parents. Go figure. Your pets get nothing. All right. This is an important one. We missed a big one. Stepchildren. You know, stepchildren are entitled to nothing if you have no will. You got to place it in the will. Organizations and institutions like your church get nothing. You know, business partners, you can't leave specific gifts to specific people. You know, if I want to leave my my mother's tennis bracelet that she gave to me to my niece, and I don't leave it to her in the will, well, that gets split amongst other people. So what is transferred under a will? Because we spent a lot of time earlier saying what is not. You know, joint accounts, life insurance, retirement plans. What is transferred by a will? Well, it's any property, the first one, bank account, a car or home, or anything else, brokerage account, owned by you, and there's no named beneficiary. Personal property, things like that tennis bracelet, or, you know, my comic book collection. Anything else that's not transferred by operation of law, like we spoke about before. Anything that doesn't have a named beneficiary. And this is a tricky one, the last one. People who say in their beneficiary form, I leave this to my estate. You know, people who do that, they feel like they're sounding erudite. You know, these aristocratic people saying, well, I leave this to my estate. Well, when you leave it to your estate, you're saying, I want property that was going to transfer outside of my will to transfer by my will. And as you see, because the court's involved and it's a pain in the neck, that's dumb, 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 dumb. Never, never, ever, never, ever, 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 never name my estate as your beneficiary on your accounts. You know, an estate tends to be something you want to avoid creating because you have to pay attorneys and court costs and wait and have the court agree to the terms of the will and your named executor, etc. What a pain in the neck. And let's go over why it's a pain in the neck. What exactly is a will? Well, a will has to be an original, written or typed legal document. Doesn't need to be typed, but it needs to be an original. If not, it's a problem. It's signed by you and witnessed by two disinterested people. I had someone who signed the will and didn't have it witnessed or notarized. Those witnesses did not have their signatures notarized. There weren't any witnesses. Invalid. The will states who receives assets still in your ownership after your death. and it names that legal representative, meaning an executor, to wind up your affairs. It can name a preferred guardian for children that you have that are minors. I know it seems like children are now minors till they're 42 years old, but whatever. Yeah, technically, legally not, even though technically yes. This document is submitted to the court at the time of your death, provided there's property transferring by your will. You know, if I pass away, most of my property transfers to my wife outside of probate. I'm smart enough to do that. I have a decent attorney when it comes to estate planning. Happens to be me. But the money is only probated if there is actually money transferring by that will. So in my case, when I die, most of the property transfers outside of probate. Perfect. Now, probate versus administration. You say, what's administration? That's when you have no will. That's when there's intestacy. Okay? A will, the legal process is known as probate. If there's no will, that property that's transferring that would transfer otherwise if you had a will under that will transfers through administration. The party who does it under your will is called as an executor. If there's no will, they're called an administrator. And who gets what under a will? You get to choose. But if there's no will, who gets what? It's the state's default that we went over. Now, these are the people that must be placed on notice when you die, when you have a will. You say, wait a minute, this is the same chart that you had before, Timins. And I say, yep, that's right. If I have no spouse and no children, and my parents are predeceased, and I have siblings, 2 of them are alive, 1's passed away. That one who's passed away has my niece and my 2 nephews, plus these 2 remaining siblings. Those are the ones that have to be placed on notice as to my will. So identify where your family falls in here. If you die, do you have a spouse and children? They have to be placed on notice. Doesn't matter that you're cutting out one of your kids. Another example, cousins. If you don't have any of these relatives, you get all the way down to cousins, you say, well, I like 2 of my cousins and 4 of them are schmucks. I don't want to leave them anything. Those 4 that you leave out, they still get a copy of that will. And people say, what? And I say, yep, that's right. They get a copy of it. They get to see you saying this cousin was a schmuck. I don't want them to get anything. All right? So that's the idea when you have probate. Parties need to be placed on notice. This is the state's priority, and this state's priority is interesting because it covers a whole bunch of things. The state's priority covers everything from who gets what money if there's no will. Remember I said this is the same as that other slide. Who gets placed on notice? I just went over that a lot. Who gets a copy of that will when you die and you're trying to have it probated? Who has the best right to serve as executor or administrator? You know, if you have a surviving spouse and you name your niece as your executor, your spouse could try to fight that because they have a better right. And then who can legally contest the will? Remember, if I leave everything to my siblings and then I have like my aunt and uncle who try to fight, they say, hey, we want to fight for what's under that will. They won't get anything. They have no legal right, right? They can't contest the will because I already have closer relatives. My siblings are closer to me than my aunt and uncle. But I suppose it depends on the sibling and the aunt and uncle. But enough of that. Now, what does the court do in this process? Well, they tend to cause a lot of trouble. And it's not their fault. It's just the process. You know, don't shoot the messenger. Don't hate the player, hate the game. You know, the court approves or disapproves of your choice of executor. So when you say in your will, I name Uncle Murray to be the executor, and they say, you know what, Uncle Murray's a felon. We don't really trust him. He's out. All right? Now, the court may require your executor to account to the court after the process is done because they want to make sure Uncle Murray didn't run away with all the money that he was administering to. Now, remember, a will is in public. When you meet with an attorney and you draft a will, it's not public until you die and someone drops it off at the court. All right? This is a problem when people lose their wills, you know, because the will is usually not waiting at the courthouse when they die. I have had that happen on rare occasions where people drop their wills off. I don't necessarily recommend that. However, will is in public until you desire to make it public. Now, the court typically only probates original wills. This is a discussion in and of itself. Wish I could discuss it more today. Hold on to your original documents. Do not lose your original will. Proving a photocopy of a signed will is a pain in the neck, and it probably won't be effective. And proving a photocopy of an unsigned will is impossible. There's no way to do it. No way. All right? more possible that people can walk on the sun than getting an unsigned, unwitnessed draft of a will admitted to probate. Okay? Go walk on the sun. That's the chances that you have. In fact, you better chance walking on the sun. Now, what does your executor do? Like I said, your executor, they step into your shoes. That means that they can do everything you can do. So they can collect your assets that transfer under probate. They can pay your expenses, not just funeral expenses, all expenses. They can pay other creditors and taxes. They hire help. So people like attorneys, accountants, if you have an apartment, they can hire movers to move out the stuff for a house. They can get rid of the armoire that you always hated. You got rid of your aunt's armoire. Congratulations, you could hire a mover to do that. Now, they can get your medical records if there was a medical malpractice lawsuit or a wrongful death lawsuit. They can bring a lawsuit, or they can defend a lawsuit. Your executor cleans out your closet, and they give money to the beneficiaries or to the trustee who will give it to the beneficiaries. So again, your executor can do everything that you can do. Enter into contracts. They become you. So if I die, my wife becomes me. How does that sound for awkward? But that's how it works. Now, here's the thing. I wish there was unlimited amounts of money in the world, but there is not, clearly. And when you die, there's a whole line of people waiting to get paid before the people you want to get the money actually get the money, right? So when you die, the first entities that are entitled to your money are the funeral home. You can't say, well, I'll just be buried in the street. Our society doesn't work like that. If you have money, you have to pay for your funeral expenses. So they're number one. Now, you knew deep down inside attorneys were going to get high up there on the list because that's just the type of people that we are. But we like to think we do a job. And the court actually says, you know what, this is going to be kind of a difficult process because I have news for you. You never do enough probates to get good at it. Someone like me who does it all the time, I have nothing else better to do, right? So they figure people like attorneys are going to be able to help move this process along, and accountants, I'll be danged if I'm going to create another income tax return for me. So we didn't want to be first. We'll let the funeral home deal with the body because we're not good with dealing with bodies. But we like dealing with courts, or we will deal with courts. Next come executor fees. Your executor can get paid for their job. I suggest you let them get paid. Preferred creditors. If you own a house with a mortgage and you owe taxes, the bank has the first right to that house. And then after that, then the taxes will get assessed. But there are preferred creditors. And then there are non-preferred. Oh, and I should add government agencies are preferred creditors. So if you have a visa bill, but you also have a tax bill, guess who's getting paid first? And yeah, deep down inside you knew, just like attorneys are going to be high up on the list, well, the federal government's higher up than American Express card is or anybody else. After all of these entities and individuals have been paid, finally the leftover money goes to your choice of beneficiaries or the default under administration. Also, if you have a minor child, your will say who your choice of guardian is for that minor child. Remember that your choice of a guardian is only one of the 13 factors that a court looks at when determining who would be the appropriate guardian for your child. The court's always asking the question. It's funny, when you take the bar exam, they're like, whenever you see family law, just say, what's in the best interest of the child? Well, they're going to ask, what's in the best interest of the child? That's going to be who is going to be named as guardian for your kid, whether that's what you want or not. Remember, it's only good for minor children. Now, facts about wills. It's okay for you to move without changing your will as long as your will was valid in the state in which it was created. It's valid in all other 49 states and territories, including American Samoa. It is a valid document. You don't need to change your will every time you move. That's good. Believe it or not, your original will is also potentially valid in other countries. That's right. There are over 100 countries that have signed more or less the International Recognition of Wills Treaty. So your will, I've seen wills that are in Mandarin. I've seen wills that are in Japanese. I have seen American wills in English, I should say, probated in France. There you go. So you can use your U.S. will to transfer foreign property. But this is what's going to happen. Let's say I have property here and property in Canada. I'm going to have the original probate here. Well, I need to get the court to give me a court certified copy where basically the United States, in this case New York, the state in particular, is going to say, okay, we promise this is a correct copy of the will. They're going to give it to the attorney who's going to forward it then to the attorney in Canada. because you only have one original will typically. So they're giving a court certified copy because they can't both hold on to the original. It's actually not physically possible to duplicate an original will after it's been submitted to the court. Talk to Einstein. Now, you can have a non-U.S. will to transfer U.S. property. So, for example, like I said, I've seen foreign wills used here in the United States, but you may need to have it translated. You know, the court says our job is not to translate into the 6,000 different languages that are available to the human experience. Now, the important thing is this. I don't know if this applies to this group of people so much that I'm speaking with today, but I'll often get people that say, well, Grandma promised me that I would get her jewelry. And the truth is this, it ain't worth a heck of a lot unless it's in writing. If it's not in writing, you'll be danged. And here's why. There's no dead man's rule in, I say New York, but it's actually most states. So here's the example. Mom says you get her jewelry when you die, and the will says your sister gets it. Your sister gets the jewelry. Yep. Now, if Mom gave you the jewelry while she's alive, then it's cool. The problem is when the will says one person's getting it, and then the jewelry just kind of disappears when Mom dies, then you got problems, right? Get it in writing. If you're being promised something, make sure that it's placed in writing. Which brings us then to trusts. Remember, trusts are will alternatives, but they don't transfer through probate. There's no court oversight. A trust is a written and signed legal document. Names of creating, administering, and beneficial parties. States the terms under which they get those monies. We'll go over all these. There is no court oversight unless there's a legal dispute. And this trust continues to exist both during your life and after you pass away. It only impacts property owned by the trust. So if your trust does not own property when you die, it's ineffective. It does nothing. People say, well, what do these trusts look like? What do the names look like? It could be the Daniel Timins Revocable Trust, or my best friend, Robert Rogers. It could be named the Robert Rogers Living Trust, or we don't even need to name a person. It's just 123 Mira Street, Irrevocable Trust. It just has a name. You need to have a name, but it can be named, frankly, practically anything. And this is how estate attorneys like I kind of like, you know, we hide assets for people who want them hidden, legitimately, of course. Now, who are the parties to a trust? Remember, trust is a written legal document, anywhere from 2 pages to like, you know, I've seen over 100-page trust, totally unnecessary. I'm sure the person who wrote it felt it was necessary to collect his fee or hers. The trust, who are the parties? The first is the person who creates the trust. We call them the creator, also known as the settlor. They create the trust and they fund the trust, meaning they change the name of their property to the name of the trust. Because remember, the trust has to own property. The trustee manages that property. They pay the income taxes that are due on the trust, and they are entitled to a small commission. And the beneficiary just kind of sits back. They have the best job. They just sit back and they just enjoy the money that the trustee gives them. You know, you created the trust as the settlor. You could say who the trustee is. It could be you, and you name the beneficiaries. It could also be you. You could be all three of these parties, as you will see. This trust is kind of bland, but it's really more important than I give it highlighting. I'm going to have to change the color in the future. But this is wills versus trust. Remember, wills transfer by probate, and it's public. Trust administration is private. No courts involved. Burden of proof of getting this will proven is on your executor. You cut out people, cut out family members, well, your executor still has to try to get that will validated. Now, with the trust, if I want to cut people out, they got to figure out that the trust exists, those people that got cut out. It's hard for them to do that. When people are trying to hide property from family members because they disfavor family members or they don't want them to get money, they create trusts. Hint, hint. You think your aunt passed away with money, but there was no probate? Money probably transferred some other way by a trust. Wills are slow and a more expensive process because the court's involved, probate is involved, court paperwork's involved. When you pass away, trusts are fast. There are minimal administrative costs involved because you put a lot of work up front. It requires minimal mental capacity to execute a will. A trust requires a little bit more mental capacity. You know, you can't go to someone when you're comatose and have a will signed, or a trust for that matter. But, you know, the level of capacity to execute a will is not necessarily very high. Now, A will just needs to be signed to be effective. For a trust to be effective, it both has to be executed and funds have to be owned by the trust. If there is no owner to the trust, or there's no property that's owned by the trust is ineffective. Which brings us then to why revocable trusts. During your lifetime, let's say you're alive, you can be the owner of the property, meaning that you're the settlor. You can be the trustee, meaning that you administer to the property, and you can be the beneficiary. If you're incapacitated, someone else can step in. There's continuity during life of your finances. And after your death, a revocable trust transfers property to other people privately. There's no probate fees, and it's faster distribution. Once I have a death certificate in my hand, I can help that trustee of the trust distribute property to the next generation. And again, revocable trusts, you tend to create the trust. The initial trustee is you until you're disabled, and then you are the beneficiary. This is the whole point. A revocable trust specifically is meant to avoid probate and really to protect these future generations. If you're incapacitated, your spouse, your kids, someone else can step in to be the trustee and you're still the beneficiary. But the more important part is this, that later the children, friends, and close family members are the beneficiaries to that. Which brings us then to why irrevocable trusts. This is important to pay attention to for a moment. The only 3 reasons to have an irrevocable trust are to provide you with creditor protection. Like if you're in construction, or I say if you're an OBGYN, you're going to get sued before lunchtime tomorrow. An irrevocable trust may protect that money. To reduce estate taxes must be an irrevocable trust. A revocable trust does not reduce estate taxes. And procure government benefits, like people who want to get on Medicaid. A revocable trust does not help you qualify for Medicaid. No, no, no. It has to be irrevocable. The idea here is you have to give up some control. So you have to say the money that goes in, this money is irrevocable. You can't take it out. It becomes an irrevocable trust. And number 2, you can't be both the trustee and the beneficiary. So here with a revocable trust, you're all 3 of these. Here you see you created the trust for an irrevocable trust. Trustee is somebody other than this person. These can't be the same people. And in fact, I should probably take away that little arrow. Now this brings us to this slide, which is an important one. This is funding trusts. And let's make sure that I am still on. We may have a little bit of a connectivity problem. I'm going to check out over here. Oops. That's not going to work. All right. Well, hopefully you guys can still hear me.
Yes, the audio stopped. Okay, I think he's coming back.
All right, sorry about that. Did we get back on? I think we're back on, correct? There we go.
Yes, I can hear you.
Okay, terrific. Sorry about that. You see my internet connection's unstable. Sorry about that. I don't know what happened.
No.
Okay. This is an important slide too, so I'm sorry. Maybe that was a good break because this is the one you really need to pay attention to. You need to have your assets either owned by your trust or name a future beneficiary to be the trust. So your life insurance policy, you don't leave it to your minor kid. You leave it to the trust that's created for your kid. So you change your beneficiary form for your life insurance. For your brokerage account or the deed to your real estate, you have to change the trust to the owner, or else you have an unfunded trust. So the idea is that's what we're trying to do here. This is an important slide. You have to fund your trust. If you created a trust with an attorney and then you don't have anything owned by that trust and you didn't change any beneficiary forms to represent, that the trust gets paid in the future, it's empty. It does absolutely nothing. No good. The idea of a trust, again, is to avoid creditor claims. An important thing to do so that if your children or your family member is getting divorced, it protects them, or if they have problems with a credit card or I don't know, Mitsubishi, whoever they have a car loan with. If a beneficiary has substance abuse problems, a trust will protect you from that. There are marital requirements as well. You may say that a beneficiary must have a prenup or a postnup or else they don't get any money. And also you can leave money in distributive pattern, such as before the beneficiary is 35 years old, I'm leaving money for their health and education. And then they get money in, certain tranches. And, this is funny because this is what all state attorneys laugh at as the plain vanilla. Some at 25, some at 30, and some at 35. So that's what trusts allow you to do, create it. Now, naming a trustee, I tend to prefer family members or good friends to be named. Because those are the people that tend to receive the money. It doesn't have to be. You can leave money to a charity. You can name your attorney or your accountant as trustee. Believe me, they'll love the extra fee. Now, that fee, by the way, is a commission. It's income. And the default is basically anything that's distributed, your trustee is entitled to 1%. So if you leave $100,000, your trustee gets 1% when that $100,000 is distributed. But if it's a trust that holds money for several years, such as for a child, those remaining assets that get transferred over year after year after year are anywhere from 0.25% to 1%. Your trustee doesn't have to accept that commission. I wish I had more time to go over unforeseen problems. I'll just share a few with you. And feel free to look at this later on. A lot of people forget to leave money for their final requirements, such as their initial estate costs. How are you going to pay for your burial? Well, if you're old enough, I tell you to prepay for it. But a lot of people say, well, I don't want to pay for it now, and then they die. Well, now someone's got to forward the money. So your final expenses are important. Leaving money to minors or disabled individuals is bad. You can't leave money to a minor beneficiary. You could leave it to an UTMA account, which I think is a bad idea because it ultimately goes to the child when they're 21 years old. Or you could say, well, I'll create a trust. There's always a backup. Leave a lot of money to a minor, and that way the court will appoint a guardian. And that way, when that beneficiary turns 18, they'll take all the money and they'll buy the fraternity. So that sounds like a terrible idea, right? Well, create a trust. Do not leave money directly to disabled individuals because you could get them kicked off of Medicaid, and your money could go to pay back Medicaid if that beneficiary is old enough. And then last but not least, some final things here. You need original documents such as your will. A trust, you don't need an original, but a will you absolutely do. I tend to tell people to keep their documents in their filing cabinet. So that tends to be a good idea. And leave a list of your nearest family members with your executor and where they're located if they don't know where they are. Do-it-yourselfers, good luck. But this is the most important thing I can bring up in these slides. You're probably going to execute the document wrong. I know it seems like it should be easy. It's not the document so much that's the problem. It's usually the fact that the beneficiary, not the beneficiary, that you execute the document wrong when you do it yourself. But if you want to look at this later, this is how I would suggest that you pursue your estate. If you are going to try to do it yourself, take a look at that slide again. This is important as well. Make sure that your executor can find necessary parties. You could create a list of all people and how they can be reached when you passed away, not just for your next of kin or your executors and witnesses, but also your former professional advisors, your accountant, your financial advisor, and your attorney. Don't assume your family members know who they are because sometimes, even though you don't have the information, someone else does. So when you die, letting them know that you have an attorney, your family members know that you have an attorney, will allow them to identify that attorney who may have a copy of the will or the original will sometimes. That's all we have time for today, folks. I'm sorry we had to hurry up those last few slides, but my name is Dan Timins. This has been a pleasure to speak with you, and thank you for spending time. If you have questions, you may ask them now, or otherwise, you may email me directly. My email is right down here. And feel free to look at my website. There are plenty of other presentations that you can look at that are both informative and sometimes a little fun.
Thank you, Danielle. It was very informative, the presentation today. Like he said, if you have any question, you can put in the Q&A box or the chat. I can see them. Thank you again. That was really wonderful for those two presentations. And if you need me to share the PowerPoint with you, you can let me know. Or you can go to the website. They all and Danielle's website. They're all there too. Again, thank you. Let's just wait a few minutes to see if there's any other questions. Other than that, thanks again.
Thank you, Shayna. And Happy New Year, everybody.
Yeah, happy New Year to you and happy holiday.